United States District Court for the District of Columbia. Plaintiff S. versus Redress Action Number. Defendant S. Summons in a redress of grievance action. 2. Defendant's name and address. A lawsuit has been filed against you within 21 days after service of this summons on you, not counting the day you received it, or 60 days if you are the United States or a United States agency, or an officer or employee of the United States described in Fed. R. Civ. P. 12. A. 2. Or 3. You must serve on the plaintiff an answer to the attached complaint or a motion under Rule 12 of the Federal Rules of Civil Procedure. The answer or motion must be served on the plaintiff or plaintiff's attorney, whose name and address are. If you fail to respond, judgment by default will be entered against you for the relief demanded in the complaint. You also must file your answer or motion with the court. Angela D. Caesar, Clerk of Court. Date, signature of clerk or deputy clerk, the United States Federal Court. Petition, in re. Eon, a sole proprietor, et al., the disenfranchised defrauded American civilians. Ex rel. The EEON Foundation sole proprietorship. Defrauded clients, et al., primary list affixed hereto, et al., v. the United States, in its commercial capacity, et al., the Federal Reserve and its member banks, et al., the 470 federal statutes that affect the lives of Americans in a host of all-encompassing areas. They gave extraordinary powers normally exercised by Congress to the executive branch of the United States, et al., and Do 1 UNLIMITED, et al., common law lawsuit pursuant to the 7th Amendment to the Constitution of the United States of America. I. Table of Contents. 1. Table of Contents. 2. Table of Authorities. 3. Federal Questions. 4. Jurisdiction. 5. Challenges. 6. Gatekeeping. 7. Introduction. 8. Persons of interest. 9. Statement of claims. 10. Affirmative relief. 11. Trial by jury demand. 12. Fractional reserve banking. 13. Continuing emergency. 14. Unjust enrichment. 15. Appearance of RICO. 16. In excess of delegatory authority. 17. Compensatory damages. 18. Punitive damages. 19. Matters for a trial by jury to decide. 20. Summarization. 21. Certification, validation, verification. 2. Table of Authorities. 1. The Federal Reserve Act and all amendments concerning notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, government obligations, and other eligible papers. 2. Title IV Section 401 Subsection 18 Paragraph 6. 3. Section 403 Subsection O. 4. March 9, 1933 Act. Amendment to the Trading with the Enemy Act. 5. National Emergency Economic Banking Relief Act. 6. Presidential Proclamation 2039, as amended. 7. Definitions. Banking institution. Bank. 8. Banking Holiday Proclamation. 9. Senate Committee on the Termination of National Emergencies. 1973 10.470 plus federal laws enacted by Congress delegating unconstitutional powers to the President. 11. Constitutional articles, amendments and provisions. 12. First Amendment. 13. Fourth Amendment. 14. Fifth Amendment. 15. Sixth Amendment. 16. Seventh Amendment. 17. Eighth Amendment. 18. Ninth Amendment. 19. 10th Amendment. 20. The preamble evidencing the posterity of the founders. 21. Federal Reserve Operating Circular 10 plus Appendix 3. 22. National Legislative Process. 3. Federal Questions. 1. The intent of Congress and Federal Reserve Notes. The intent of the United States Congress as expressed in the Congressional Record and the United States Statute at Large. 59 Stat. 237 Section 2. Which amended the circulation of banknotes, replacing them with Federal Reserve notes and maintaining the par value, redemption value, and receivable value of eligible papers. Such notes, drafts, bills of exchange, and bankers' acceptances so deposited as security. Such notes shall be the obligations of the Federal Reserve Bank procuring the same. Shall be in form prescribed by the Secretary of the Treasury. Shall be receivable at par in all parts of the United States for the same purposes as are national bank notes. And shall be redeemable in lawful money of the United States on presentation at the United States Treasury or at the bank of issue. According to the Congressional Record of March 9, 1933, specifically pages 78 through 83, it appears by said record that it was the intent of Congress to make these eligible papers, which included government contract obligations, any notes, which according to the record includes promissory notes, drafts, bills of exchanges, bankers' acceptances, or trade acceptances as coins and currencies of the United States as identified by the June 5, 1933 Act and its Congressional Concurrent Record. If this is the case, then promissory notes do indeed have value, and if they have value, is that value not to be indicated on any billing accounting statement showing account history transactions? According to Congress, the value of these notes and other eligible papers were to be at par, indicating face value. 59 Stat. 237 Section 2 specifically highlight that in no event shall the collateral security promissory notes accompanied by the application now identified as Federal Reserve Operating Circular 10 Appendix 3 be less than the total amount of Federal Reserve notes applied for, evidencing and documenting the par value intent. Does it not? 2. Under what authority does a lender and/or purported creditor get to convert a non-negotiable promissory note into a negotiable promissory note without the consent and knowledge of the maker? 3. Under what authority does a lender presume to operate to take a non-negotiable promissory note that has been notarized and trespass upon the notary seal by placing an endorsement on the instrument without a notary and without the maker's consent and/or knowledge, converting the non-negotiable promissory note into a negotiable promissory note whereby they get to redeposit such an instrument for investment purposes and/or unjust enrichment purposes such as fractional reserve banking? 4. When Congress authorized the United States Treasury to seize all the gold from individuals, corporations, and partnerships, it appears to have violated the Takings Clause. They were, by law, supposed to provide just compensation by making these notes, drafts, bills of exchange, bankers' acceptances, trade acceptances and/or other government obligations equal in value to national banknotes, as prescribed in law. Is this not in any way the interpretation? Congress acknowledged this by stating, gives supreme authority to the Secretary of the Treasury of the United States to impound all the gold in the United States in the hands of individuals, corporations, or companies. The last section of the bill provides for the issuance of new money. I refer to Section 401, which reads, upon deposit with the Treasurer of the United States of all contract obligations of the United States, or any notes under the Federal Reserve Act obligations that are deposited as the security and gold for reserve notes are placed in the hands of the Federal Reserve agent. 5. Does this not suggest that notes, drafts, bills of exchange, bankers' acceptance. Trade acceptances along with other government obligations should be the compensation for surrendering gold for public use. The gold that is given up by the people in the present crisis should be delivered to the government. It should be used to issue additional money upon which the people will not have to pay interest while it is in circulation. 6. However, people are charged interest and do not have access to Federal Reserve notes in exchange for promissory notes as Congress intended. 7. Do the people have the right to demand the return of gold or have the federal government order the Federal Reserve Bank to compensate for denying access to currency and banking structures? 8. Does the United States Congress possess the constitutional authority to delegate its legislative powers to other branches of government, specifically to the executive branch, as evidenced by the reported enactment of over 470 federal statutes granting the President extraordinary powers beyond those normally exercised by Congress? All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Separation of Powers Clause. The principle of separation of powers is articulated throughout the Constitution, primarily in Articles I, II, and III. The concept is inferred from the structural framework of the Constitution and the allocation of powers among the three branches of government, and it is thus defined in the Non-Delegation Doctrine. Point 1. Key provisions highlighting the separation of powers include Article 1. Section 1 establishes the legislative branch and vests all legislative powers in Congress. Article 2. Section 1 establishes the executive branch and vests the executive power in the President. Article 3. Section 1 establishes the judicial branch and vests the judicial power in the Supreme Court. 9. Does the delegation of authority under the amendment to the Trading with the Enemy Act having a military legislational foundation as well as 1 in J.W. Hampton, Jr. and Company, v. United States, 1928, the Supreme Court articulated the non-delegation doctrine, which holds that Congress cannot delegate its legislative powers to another branch of government without providing sufficient guidance and standards. The court stated that while Congress may delegate authority to administrative agencies, it must provide an intelligible principle to guide the exercise of that authority. In Panama Refining Co. v. Ryan, 1935, the Supreme Court further elaborated on the non-delegation doctrine, emphasizing that Congress must provide clear guidelines and limitations when delegating legislative powers to administrative agencies. The court struck down a provision of the National Industrial Recovery Act, ruling that it unlawfully delegated legislative authority to the President. In Whitman v. American Trucking Associations, Inc., 2001, the Supreme Court reaffirmed the principle that Congress cannot delegate legislative power without providing an intelligible principle to guide the delegated authority. Wayman v. Southard, 1825. 1. The U.S. Supreme Court held that Congress could not delegate strictly and exclusively legislative powers, but could give away other powers. The court noted the imprecise bounds of the discretion Congress could give other branches. This case introduced the idea that there are limits to delegation but also recognizes the possibility of delegating certain powers. Panama Refining Co. v. Ryan, 1935. The court held that a law governing hot oil violated the non-delegation doctrine. This case represents a stricter application of the doctrine, leading to the invalidation of a statute. Application: infringe upon the separation of powers doctrine by extending presidential authority beyond the scope of constitutional authority. potentially subjecting civilian population to military rule? 10. In accordance with the amendment to the Federal Reserve Act of March 9, 1933, which amended Title IV Section 401 subsection 18 paragraph 6, which outlines the deposit of obligations of the United States, in conjunction with any notes, drafts, bills of exchange, bankers' acceptances, trade acceptances to be at par with the Federal Reserve notes as they serve as collateral for the issuance thereof. Does this practice raise concerns regarding the appropriate application of the law as the civilian population are being denied access to having their instruments be received at par as intended by the United States Congress? Wherefore, it appears the courts have held that these instruments are bogus, invalid, without merit, frivolous, having no legal foundation, contrary to the aforementioned amendment by Congress on March 9, 1933. Are the courts circumventing the law by such rhetoric and interfering with the right of the people to access commerce in the United States as prescribed in law? 11. Emergency powers and constitutional authority. The 1973 report of the Special Committee on the Termination of the National Emergency, Senate Report 93-549, uncovered in excess of more than 470 provisions of federal law that delegated and conferred extraordinary authority to the President, authority normally exercised by the Congress. This conferred enough authority for the President to rule the country bypassing normal constitutional processes, affecting the lives of the American civilian population in a host of all-encompassing manners and areas. Where is the delegation of authority for this extraordinary unnormal process? If there is no delegation of authority, are these acts by Congress, as evidenced in congressional records, and perpetuated over 470 times, unconstitutional on each occasion? 12. Long-term emergency proclamations. The Senate report noted that Congress had transferred increasing legislative power to the President since the Presidential Proclamation 2039 and its continuation enacting counterpart, the National Emergency Economic Banking Relief ACT of March 9, 1933, allowing the President to enact laws and take actions normally requiring legislative process and congressional approval. 4 of these proclamations remain in effect to the present day. 1 by Roosevelt, 1 by Truman, 2 by Nixon, affecting American lives in circumvention of the original intent of the Constitution and in other unconceivable manners. Does this make the unforbidden acts of the United States Congress treasonous, as well as unconstitutional? And what are the supporting facts and legal conclusions of your answer to this question and each of the others associated with this federal question section? Specifically, 13. Continued effect of ongoing emergencies. United States Congress in enacting the National Emergencies Act specifically stated that they were not explicitly terminating the following emergencies: Franklin Roosevelt's 1933 declaration under the Trading with the Enemy Act, Harry Truman's 1950 declaration related to the Korean War, and 2 by Nixon. As these 4 proclamations still affect, it matters not Congress's reason for not terminating them. After determining that these acts were in and of themselves unconstitutional, what matters is that they remain unconstitutional. How say you? 14. Delegation of legislative authority. The Senate Special Committee report highlighted the gradual power shift to the President, which permitted the President to legislate without congressional approval. The legislative process does not permit Congress to delegate its role to any other branch of government, and no court opinion can override this constitutional limitation. Is this interpretation correct, being that the laws of the United States must proceed through legislative enactment? 15. Presidential powers in crises. The unconstitutional effect of these long-standing emergencies was to enable the president to override constitutional protections and prohibitions against government actors and/or powers, prohibiting any branch saved by Congress in the exercise of legislative powers at all times. The passage of the National Emergencies Act in 1976, which terminated all existing emergencies except for Roosevelt's 1933, Truman's 1950 and two of Nixon's declarations, as noted within the act itself, confirms the unconstitutionality of the previous proclamations, which also invalidates the 470-plus laws enacted as a direct result of these unconstitutional proclamations. Given that these proclamations are of a military nature, can they be applied to the American population without violating the Constitution? And once declared unconstitutional by Congress and evidenced by the enactment of the National Emergencies Act of 1976, does that make all of the other laws associated with the 470 unconstitutional laws unconstitutional and having no force in law, at law, and inapplicable in its application against the American people? 16. Presidential authority conferred in legislative and judicial functions. The extant effect of these long-standing emergencies enables the president to wield legislative powers without the checks and balances typically provided by Congress. Under what circumstances is the Constitution said to grant such powers, allowing the executive branch to exercise legislative powers? Can you provide the section and proof of the original intent for such processes? If the president can exercise legislative powers, does that imply he could also wield judicial power if Congress gave him such authority, effectively becoming a monarch? Is this even feasible under the blueprint known as the Constitution? 17. Implications for due process and justice. The Senate report indicated that the delegation of extraordinary powers to the president during any declared national emergency, without proper termination mechanisms, allows the president to act in a legislative capacity, circumventing the separation of powers. Does this mean Americans must endure without due process, justice, redress, or correction this tyrannical quilting of power to no when? Who determines other than the president whether or not the exercise of these powers are necessary? When did the people volunteer to subject themselves to such subjugation and/or involuntary servitude? Because it affects the lives of Americans in a host of all-encompassing areas. This extraordinary grant of legislative powers to the executive branch, does this not violate the provisions of the Constitution and the Northwest Ordinance prohibiting involuntary servitude? Although the questions are compound, the complexities surrounding the questions require the answers to be specific, non-general in foundational nature, supported by facts and conclusions of law due to the impact on the individuals affected there. Bombing. Reliance on the law is paramount. The law, we appear to be a lawless society. With the law, we appear to be a civilized society. The petitioners would rather live in a civilized society, and therefore we ask the aforementioned questions so as to justify the conduct of the defendants. IV. Jurisdiction. 1. This court holds jurisdiction over the instant matter, as afforded by the 7th Amendment of the Constitution of the United States. The 7th Amendment guarantees that in all civil cases where the value in controversy exceeds $20, the right to trial by jury is preserved and is not subject to re-examination by any court. That the decisions rendered by a jury, which is a right of choice, and since this choice is that of the parties, the right to choose a jury is a right secured by the 7th Amendment, cannot be overturned, nor can the right to a trial by jury be circumvented by any party, agency, department, or branch of government. 2. Additionally, This court has inherent jurisdiction over the controversies involving the 470 laws enacted by Congress, each challenged herein, in addition to the 4 executive proclamations which remain effective to the present day, determined by Congress via the enactment of the National Emergency Act, documenting the unconstitutionality of the presidential proclamations associated thereto as a whole. 3. Each of these matters are cognizable by this court as controversies under the laws of the United States, thereby falling within the purview of the judicial branch of the United States government as prescribed in the Constitution for the United States of America, Bill of Rights. 4. Furthermore, jurisdiction over the defendants, the Federal Reserve Board of Governors and the Federal Reserve Banks as specifically delineated in the Federal Reserve Act. These entities, while independent of the constitutional framework and not part of the United States government, are within this court's jurisdiction. They are subject to legal action as they have consented to be sued, as stipulated by law. Notably, the Federal Reserve is a private corporation registered in Delaware and operates autonomously from governmental oversight. Thus, it is not shielded by sovereign immunity. Versus challenges jurisdiction and statutorial. 1. We hereby assert the following constitutional challenges, relying on the premise that the courts are endowed with judicial knowledge of the law and its delegation. Notwithstanding this knowledge, there has been a neglect of the parties' contractual rights, particularly concerning contracts that incorporate arbitration clauses after a notice of change in terms of agreement. The law permits and allows for parties to a contract to change the terms of the agreement so long as the opposing party is notified and has an opportunity to opt out. In cases where this has been the norm, the courts have upheld this practice. When it suits their needs apparently, the opposition will possibly make claims of indemnity, relying in part on the provisions under Federal Reserve Operating Circular No. 10, Sections 12.3 and 13, which discuss attorneys in fact and indemnification, purportedly protecting them from prosecution. We challenge the legality and conscionability of these sections and the operating circular in its entirety, as the operating circular demands a party enter into this agreement in order to exercise their rights secured under the Act, rights associated with the Treasury seizing all the gold in America so that no gold coin can be made and thus the public has no access to what is deemed monies of the United States. We do hereby challenge the unconscionable nature of Federal Reserve Operating Circular 10, Appendix 3, requiring a borrower to surrender all of their rights, and to indemnify Federal Reserve agents, banks, institutions, members for criminal conduct. The law does not allow any person to ignore criminal conduct and/or to waive criminal conduct of any party, and to completely indemnify a party who assumes full general power of attorney irrevocably without notifying the U.S. borrower of the consequences associated thereto or the intentions to convert the note, which is non-negotiable, to a negotiable promissory note. Either way, Federal Reserve Operating Circular 10 Appendix 3 acknowledges the collateral for the loan as being the promissory note, which remains in possession of the holder in due course. If the promissory note is the collateral and security for the loan, then the agreement is satisfied once the holder takes possession of the note, as the Law 59 Stat. 237. Section 2 says that it is to be received at par, face value, and as agreed, the total balance has been paid, accepted and not dishonored. 1. We do hereby challenge Congress' ability to redefine what the term gold meant within the Constitution. The law must be taken within its context. And since the law stated that no state may make nothing but gold or silver coin as money, in this context Congress is not defined as no state. nor having exclusive authority as to making money. Congress was only given the authority to regulate money, commerce. If we go according to the strict interpretation of the Act, and the definition of gold and its context within the Constitution, gold meant the mineral, the precious metal, and not just a word or terminology. So, in the Congressional Record of March 9, 1933, when Congress said, under the Federal Reserve Act, obligations that are deposited as the security and gold for reserve notes are placed in the hands of the Federal Reserve agent, they didn't have the authority to redefine what gold was. However, by stating that this new gold were promissory notes, bills of exchange, bankers' acceptances, trade acceptances, and/or other government obligations, Congress was thereby establishing that these new monies were to be such notes, drafts, bills of exchange, and bankers' acceptances so deposited as security. Such notes shall be the obligations of the Federal Reserve Bank procuring the same, shall be in form prescribed by the Secretary of the Treasury, shall be receivable at par in all parts of the United States for the same purposes as are national banknotes, and shall be redeemable in lawful money of the United States on presentation at the United States Treasury or at the bank of issue. The petitioner's notes, drafts, bills of exchange, bankers' acceptances, trade acceptances and/or other government obligations are not being received at par, and the courts are deeming that these lawful items that are to be used for the same purposes as legal tender, i.e., national banknotes, are bogus, worthless pieces of paper, having no monetary value, and not accepted in all parts of the United States and are not at par with Federal Reserve notes, which is the complete opposite of what the law, the Federal Reserve Act, Title IV, Section 401, Subsection 18, Paragraph 6 says. And it is believed that this is because many of the court's judicial officers are invested in fraudulent, bogus, worthless mortgage-backed securities, thus they are receiving a financial gain as a result of their looking the other way, so to speak, causing damage to both property and person respecting the petitioners and allowing for unjust enrichment of the Federal Reserve Bank for their operating in conspiracy with the lawyers representing these entities to deprive the people of their property in order to make further unjust enrichment and/or gain by perpetuating this process time and again. And we hereby bring forth our claim of this unconstitutional and unlawful process, as it violates the RICO Act among other felonious laws. 2. Additionally, as stipulated under 59 Stat. 237 Section 2 and Section 16. 2. of the Federal Reserve Act provides that the Federal Reserve agent, lender, receives Federal Reserve notes on behalf of the U.S. borrower. These transactions mandate that the promissory note and/or bill of exchange and/or draft and/or bankers' acceptances and/or government obligations and/or trade acceptance, as defined by Congress, is to be received at par value, and is redeemable through the United States Treasury or at the Federal Reserve Bank, pursuant to Title IV, Section 401, Subsection 18. 6. The law categorically states that such notes, drafts, bills of exchange, bankers' acceptances, and trade acceptances are to be accepted at par akin to national banknotes, thereby serving as collateral and security, binding the Federal Reserve and member banks to compliance. They have not complied. Not only have they deposited these notes and proceeded to then fractional reserve the deposit associated with the fractional reserve banking practice, they in turn receive the monies from the Federal Reserve Board of Governors as prescribed in the Federal Reserve Act, Section 16. 4. On behalf of the United States borrower, and fractional reserve this deposit, never compensating the U.S. borrower, but they get to take the mortgage and trade on the secondary market. thus receiving an additional source of profit and/or gain from the trade on the market, never compensating the U.S. borrower. Then they claim that there is an outstanding debt when the deposit of the promissory note satisfied the contractual agreement as prescribed by the agreement itself, because the borrower only promised to pay back what was being loaned, and the promissory note, which may at no time be less than the total amount of Federal Reserve notes applied for, served as collateral, tender, offer, security, par value, receivable and redeemable payment. This unjust enrichment scheme has been ongoing for decades, and the courts, in conjunction with the financial institutions and the Federal Reserve Board of Governors, along with the Federal Reserve Bank, along with United States Treasury, who appear to be in an apparent conspiracy and racketeering scheme to defraud the American people. Each of our clients are allowed by law to create tax credits. Promissory notes and/or bills of exchange are for the same purposes as national banknotes, which were deemed legal tender. That definition has not changed. The key section is, when required to do so by the Secretary of the Treasury, each Federal Reserve agent shall act as agent of the Treasurer of the United States or of the Controller of the Currency, or both, for the performance of any of the functions which the Treasurer or the Controller may be called upon to perform in carrying out the provisions of this paragraph. This allowed the Secretary of the Treasury to direct the Federal Reserve agents to perform duties normally carried out by the Treasurer or Controller of the Currency. Specifically regarding the issuance of the Federal Reserve banknotes in 1933, the Act states, such notes shall be the obligations of the Federal Reserve Bank procuring the same, shall be in form prescribed by the Secretary of the Treasury, shall be receivable at par in all parts of the United States for the same purposes as our national banknotes. So while the Federal Reserve banknotes were obligations of each regional Federal Reserve Bank, their form and status as being receivable for all purposes as national banknotes was prescribed by the Secretary of the Treasury. Therefore, for the stated purpose of issuing the 1933 Federal Reserve banknotes as an emergency currency measure, the Emergency Banking Act did temporarily authorize the Federal Reserve to effectively act under the guidance and regulations of the U.S. Treasury Department, treating the notes as equivalent to legal tender currency issued by the Treasury itself. If bills of exchange are indeed legal tender and/or legal tender equivalent and/or receivable in all parts of the United States and/or a currency of the United States and/or an obligation of the United States, and when a party sends it for tendering payment to any company, and the company so receiving the item, does not offset the debt as required in law, then the alleged debtor gets to write off the amount owed as a result of the dishonor. The Internal Revenue Manual under Bills of Exchange Campus Support, https www.irs.gov/erm/part21/erm_21-001-007R #item-13990427776477760 literally says you can send a bill of exchange to the Internal Revenue Service and a party can point out that the losses associated with the specified issuance of the bill of exchange is deemed valid currency in the United States, that if it is ignored, then the bill of exchange can be now utilized for offset and discharge as such was received as the deduction for the net operating loss for the value as stipulated in law, at par, which makes the instrument that was deposited with the Internal Revenue Service redeemable and receivable in all parts of the United States as prescribed by Title IV Section 401. Subsection 18 Paragraph 6 outlined in 59 Stat 237 Section 2 incorporated in the Federal Reserve Act. Section 16 Section 2. Section 4. C. it was United States Congress who gave the notes, drafts, bills of exchange, bankers' acceptance, trade acceptance and/or other government obligations. This legal status respecting tender, as according to the Supreme Court of the United States, and the various legal tender cases, Congress has the capabilities of determining legal tender status in the Treasury has granted the authority to the Federal Reserve through fractional reserve banking to create legal tender. See Modern Money Mechanics for clarification. 3. According to the Federal Reserve Act, upon approval of a loan by the Federal Reserve Board of Governors, they are compelled by law, under Federal Reserve Act Section 16. 4. To issue Federal Reserve notes to the local Federal Reserve agent for the U.S. borrower. These deposits initiate a process of fractional reserve banking. This is inherently an unconstitutional mechanism that results in unjust enrichment, a claim substantively addressed in this petition. By taking these mortgage-backed securities and trading on the secondary market, knowing that the promissory note is collateral and security for the loan, i.e., payment, making these mortgage-backed securities worthless because they're not backed by a mortgage because the mortgage has been paid in full by the U.S. borrower. This appears to violate the Securities and Exchange Act, and the Securities and Exchange Commission, being aware of this fact, continue to allow these bogus securities to infect the market, causing global crises and meltdowns such as the 2008. The banks received $28 trillion from Congress. According to the congressional record, only pay back a fraction of that. The U.S. borrower only received the benefit of refinance or be subject to eviction. That appears fair. Let's re-examine. The financial institutions got to fractional reserve $28 trillion, and the United States borrower was subject to having to repay a loan for which they were accused of being deadbeat borrowers trying to game the system. Yes, that seems fair to the unreasonable, and we do hereby bring forth our challenge to this unconstitutional scheme, which appears to amount to insurrection, tyranny and rebellion as defined in the Constitution for the United States of America. 4. This systemic failure resulted in unjust enrichment which appears to constitute racketeering under the RICO Act, as banks profit from trading these promissory notes and associated mortgages on the secondary market without due compensation to the borrower. This forms a clear case of attempted fraud, attempt to conspire to defraud, federal electronic communications violations, theft by fraudulent process, and placing false and misleading information on the public record, and other legal as well as lawful violation, facilitated by both the banking institutions and the judicial system operating in tandem. As noted above, the financial institutions, in order to accomplish the scheme, have to convert the non-negotiable promissory note into a negotiable promissory note, knowing that they're violating contract law as identified under the Uniform Commercial Code Article 3, Section 407, as adopted by every state in the Union. They proceed to receive several benefits such as redepositing. Once a note is negotiable and sold, the proceeds from the sale can potentially be deposited back into the bank, counted as a new deposit. Fractional reserves. These new deposits can then be used to support further lending under the principles of fractional reserve banking, potentially multiplying the bank's ability to lend and generate interest income. Balance sheet management. Asset enhancement. By converting notes to negotiable instruments, banks can enhance their balance sheets by increasing the apparent liquidity and value of their assets. Capital requirements. This can help meet regulatory capital requirements or improve financial ratios used to evaluate the bank's financial health. Legal perspective and court opinions. Altering a promissory note without consent is illegal and has been addressed by courts. which have consistently held such actions to be fraudulent and void. Here are relevant cases and legal principles. Unauthorized alteration and fraud. Restatement. 2nd. Of Contracts Section 7, 1981. Principle. Unauthorized alterations of a contract, including promissory notes, render the altered instrument void. UCC Section 3-407. Material alteration. Principle. Material alteration discharges any party whose obligation is affected unless the party assents or is precluded from asserting the alteration. Case citations. Examples. The unauthorized alteration of a promissory note. Opinion. The court held that an unauthorized material alteration of a promissory note rendered the note void, as the alteration changed the obligations without the maker's knowledge and consent. Holland v. Burke, 58 NY 284, 1874. The consequences of unauthorized alterations to a promissory note. Opinion. The court ruled that unauthorized alteration discharged the maker's obligations. The alteration was significant enough to affect the note's terms, making it unenforceable. Schwartz v. Schwartz, 112 Cal. App. 2D 813. 1952. The legal implications of unauthorized alterations. Opinion. The court emphasized that material alterations without consent make the note unenforceable, reinforcing the principle that financial instruments' integrity must be maintained. First National Bank of Cincinnati v. Pepper, 454 F.2d 626. 2d CIR. 1972. While financial institutions may have motives to convert non-negotiable promissory notes to negotiable ones, such actions without the maker's consent are illegal. The primary benefits to the bank would be increased liquidity, potential to enhance their balance sheet, and greater ability to use the notes in fractional reserve banking. However, such conduct is considered fraudulent and is subject to severe legal consequences. Courts have consistently invalidated notes altered without consent and held the altering party liable. Now the public is waiting to see if there is consistency or hypocrisy. 5. In addition, we challenge the constitutional validity of the 470 statutory laws and the Comprehensive United States Code. Proffering their enactment did not adhere to requisite legislative procedures. These 470 laws have already been deemed by Congress to be unconstitutional, delegating their legislative authority to the President at any time. The very fact that Congress delegated legislative authority to the President without oversight, as identified by the Senate Committee, documents the unconstitutional nature of these 470 laws. When Congress enacted the National Emergency Act, after identifying these unconstitutional provisions and enacting the National Emergency Act to prevent such unconstitutional acts in the future and terminating, yes, that's right, Congress had authority to terminate these acts, chose to leave for such unconstitutional acts in place which still affect the lives of Americans, and a whole host of unconstitutional areas, making the remainder of these acts unconstitutional and the provisions of the National Emergency Act associated thereto unconstitutional as determined by Congress and the enactment of the Act in the first instance. 6. Then there is the U.S. Code, not fully ratified by Congress through a legitimate legislative process, not enacted by the United States Congress as is required in law, as Congress only enacted the title of certain codes as positive law title. Yet the context and the substance beneath the title has not been enacted by Congress. Therefore the courts deem it as prima facie, until someone brings forth the presumption, this challenging these acts that are not enacted as law is unconstitutional by bringing forth a Preponderance of evidence to the contrary is in and of itself unconstitutional, and we do hereby challenge even that process. The United States Code has no enactment clause, is not signed into law by the President after being voted on by the whole Congress as required of the legislative process. The Law Revision Council are not elected officials, have no authority in law to recodify any law, and not law be applicable to the civilian population. The circumventing of this process is well established and unconstitutional according to the procedure circumventing, and we do hereby bring forth this lawful challenge to such process. 7. We further contest the judicial handling of arbitration agreements. Despite the agreements being properly entered into by the parties and without a single party opting out of the agreements remain binding and unchallenged. Courts have permitted certain unscrupulous parties to contest arbitration awards beyond the statutory calendar 90-day limit, and such is inconsistent respecting the Act. The courts have applied excessive filing fees, not against every applicant applying for judicial confirmation of an award in accordance with the United States Arbitration Act, not only against those who did not use the American Arbitration Association and/or JAM. Both agencies contracted with the court. The courts throughout the United States, in particular Hawaii, Arizona, California, New Mexico, Mississippi, Virginia, Wisconsin, Wyoming, Minnesota, Texas, Louisiana, Georgia, Washington, Utah, Colorado, and several others, have consistently reversed arbitration decisions on confirmation solely because of the aforementioned fact that it was determined that the Arbitration Association was a private arbitration association and not one sanctioned by the court, which is completely in circumvention of the United States unanimous decision in Henry Schein v. Archer and White Sales, 2019. The court proceeded to haul many of these arbitrators, which are protected by quasi-judicial immunity, into court to testify as to things not directly related to their arbitral duty. These practices not only suggest a form of judicial retaliation but also undermine the mandated capacity of arbitrators as defined by the Supreme Court in Henry Schein v. Archer and White Sales, 2019, which affirmed that arbitrators, adhering to the law and the arbitration agreement, perform a judicial function and are immune from prosecution and/or interrogation by any court. The courts have allowed corporations like Penny Mac, Inc., et al., to bring forth claims of racketeering, conspiracy, fraud, and a motion to vacate, to proceed which has already been determined is inapplicable to such proceedings. The Court of Mississippi issued a $1.3 million decision and then blocked all efforts at appeal despite the $505 appeal fee being paid, placed false and misleading evidence on the record stating that it had not been paid and had not been received, denying the petitioners their right to appeal as provided by the right to petition for redress under the Constitution for the law of the United States of America. 8. These judicial actions breach the integrity of arbitration agreements and threaten the impartiality and independence of arbitration, compelling an urgent and directed resolution of these discrepancies, making not only the judicial officers in the respective courts but also the judicial branch of government liable for the complete absence of all jurisdiction acts of these judicial venues. V. Gatekeeping claims. 1. This section addresses the systematic denial of access to judicial redress, constituting illegal gatekeeping in violation of constitutional and statutory rights. This gatekeeping has particularly manifested in the refusal of courts to allow challenges to foreclosure proceedings, where the promissory note, or bill of exchange, was the payment exchanged for the extension of credit and advancement of Federal Reserve notes. In accordance with Federal Reserve Operating Circular No. 10 Appendix 3, Federal Reserve Act Section 16, 2, 4, and 59 Stat 237 Section 2, Presidential Proclamation 2039, and the Congressional Act of March 9, 1933. 2. Violations and legal framework. Promissory note as payment. Courts have consistently failed to acknowledge that the promissory note, intended by law to be received at par value, fulfills the debt obligation. This misapplication of law facilitates unjust enrichment of financial institutions via fractional reserve banking, where banks leverage the same deposited promissory notes to create multiple loans, violating the intent of lawful credit extension. 3. Collusion and RICO violations. Evidence suggests a collusion between financial institutions and judicial systems to perpetuate these malpractices, potentially constituting racketeering activities under the RICO Act. This systematic exploitation of promissory notes significantly harms borrowers and undermines the integrity of judicial proceedings. 4. Relevant Supreme Court precedents asserting access to government. Biden v. Nebraska, 2023, confirms that no agency head can reconfigure existing laws in a way that impedes access to governmental resources or redress. American Hospital Assen v. Becerra, 2022, affirms a strong presumption in favor of judicial review of final agency actions, ensuring that individuals can challenge governmental actions that obstruct access to governmental services. Salinas v. Railroad Retirement Board, 2021, upholds the right to judicial review when an agency refuses to reconsider a prior benefits determination, emphasizing the critical nature of accessible and accountable governmental operations. 5. Legal recourse and enforcement. Transparency and accountability. Any gatekeeping violation must be immediately reported to the President, Congress, and the Comptroller General as mandated by law. 6. Disciplinary and civil penalties. Entities and individuals responsible for gatekeeping violations may face both administrative, disciplinary actions and civil penalties. 7. Criminal and legal liability. Severe cases of gatekeeping that involve fraudulent or corrupt activities may lead to criminal charges. Furthermore, government agencies can be held legally liable through lawsuits from affected parties seeking compensation for damages caused by such violations. V. Introduction. 1. In March 1933, amidst the depths of the Great Depression, President Franklin D. Roosevelt took swift action to address the nation's financial crisis. Only 3 days into his office, he issued Presidential Proclamation 2036, summoning an emergency congressional session on March 9, 1933. This was swiftly followed by Presidential Proclamation 2039 on March 6, 1933, which declared a national banking emergency under the auspices of the Trading with the Enemy Act. This act typically allowed for such declarations during times of war with foreign nations but was repurposed to address the domestic economic crisis. 2. During the special joint session of Congress on March 9, 1933, a bill was hastily introduced that had neither sponsorship nor proper introduction on the congressional floor. Despite vocal objections and concerns about the circumvention of the standard legislative process, Congress passed the National Emergency Economic Banking Relief Act within less than 12 hours of debate. This act not only indefinitely continued the national emergency banking holiday initiated by Roosevelt but also sanctioned the issuance of eligible papers such as notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, and other government obligations. These instruments were issued as substitutes for the gold seized from the American public, purportedly as just compensation. An action this lawsuit contends did not meet the just compensation requirements of the Fifth Amendment. 3. This act marked the beginning of a troubling era where Congress enacted approximately 470 federal laws that conferred extraordinary powers upon the president, fundamentally altering the landscape of American constitutional law and governance. These laws, born out of the alleged necessity of the national emergency, have continued to affect the lives of the American populace across various dimensions, often bypassing normal constitutional processes and checks and balances. 4. Furthermore, despite the legal framework equating eligible papers with Federal Reserve notes, as further modified by the Act of June 12, 1945, Section 3 and/or 59 Stat. 238 Section 3, which replaced Federal Reserve banknotes with Federal Reserve notes, the implementation has been fraught with inconsistencies and failures. Financial institutions and the Federal Reserve Board of Governors are accused of not reflecting these transactions accurately on the U.S. borrower's ledger, leading to fraudulent foreclosures and deceptive financial practices that appear to defraud U.S. borrowers on a national scale. This malpractice has not only affected hundreds of millions of Americans but has also been implicated in contributing to global financial crises, unjustly labeling U.S. borrowers as economic detractors. 5. The complaint demands an immediate halt to all foreclosures related directly to loans where U.S. borrowers have petitioned for the issuance of Federal Reserve notes as outlined in Federal Reserve Operating Circular 10 Appendix 3. It requires that all such loans be thoroughly accounted for, with financial institutions mandated to provide clear and transparent documentation of their accounting practices. 6. This lawsuit seeks to demonstrate the ongoing failure to adhere to the laws as intended by the United States Congress and the principles upheld by the American people, advocating for the disassembly and declared unconstitutionality of these 470 federal statutes. The termination of these unlawful acts and the accountability of those who perpetrated these acts against the American populace are imperative, as their unlawful nature negates any possible claims to immunity. 8. Persons of interest. 1. Federal Reserve Board of Governors. The Federal Reserve Board of Governors is implicated for its failure to adhere to legal standards in the execution of its duties, specifically in managing the issuance and valuation of Federal Reserve notes and other financial instruments. This body has a documented requirement to follow the law as written, which this lawsuit contends has not been met, resulting in misapplications that have adversely impacted the U.S. economy and individual civilian population. 2. United States Congress and House and General Assembly. This lawsuit accuses Congress of systemic misapplication of the legislative process, particularly in how the United States Code has been compiled and enacted. It is alleged that many parts of the code were not properly introduced, authored, or ratified as positive law by Congress but are still applied to the detriment of the American populace. This misapplication is claimed to cause significant harm and injustice to the civilian population. 3. The executive branch. Focused on the issuance of Presidential Proclamation 2039 under the Trading with the Enemy Act. This lawsuit challenges the application of a military act to the civilian populace. It is proffered that the president's actions, taken in a military capacity, unlawfully encroach upon the constitutionally secured rights otherwise known as the unalienable rights of American civilian population, violating due process as guaranteed by the Constitution. 4. Banks and financial institutions. Financial institutions across the United States are accused of falsely denying the legal and financial parity between bills of exchange, bankers' acceptances, drafts, notes, and Federal Reserve notes. Despite legal statutes to the contrary, these institutions are alleged to have engaged in practices that classify legitimate financial instruments as frivolous or meritless, contributing to widespread financial deception and wrongful foreclosures. 5. Judicial officers. This group is accused of conspiring with financial institutions and legislative bodies to deprive the American civilian population of their constitutionally secured rights, including property rights, the right to earn a living, and the right to engage in commerce. The lawsuit contends that such actions are part of a broader scheme for profit, centered around mortgage-backed securities, which have perpetuated significant economic injustices against the populace. 6. Plaintiffs. The Aeon Foundation. Representing a collective of over 300 clients, the Aeon Foundation, a nonprofit organization, challenges the unconstitutional restrictions on individuals' rights to assign their power of attorney or to choose their counsel. This challenge is integral to the lawsuit, asserting the right of individuals to legal representation of their choice. Contrary to the prevailing assertions that legal representation must be through a licensed attorney. Ix. Statement of Claims. 1. Failure to follow legal standards. The Federal Reserve Board of Governors did not comply with the legal requirements prescribed in the Federal Reserve Act for issuing and valuing Federal Reserve notes, contributing to systemic financial discrepancies. 2. Legislative misconduct. The United States Congress bypassed established legislative processes when compiling and enacting significant parts of the United States Code, leading to the application of laws that were not duly legislated. 3. Improper legislative ratification. Many sections of the United States Code were implemented without proper introduction, authorization, or positive law designation by Congress, yet they have been enforced to the detriment of the civilian population. 4. Unlawful application of military authority. Presidential Proclamation 2039 was issued under the Trading with the Enemy Act, applying military authority inappropriately to civilian matters and infringing upon constitutionally secured rights. 5. Misrepresentation of financial instruments. Financial institutions across the United States have misrepresented the legal status and equivalence of financial instruments like bills of exchange and Federal Reserve notes, leading to unjust financial practices. 6. Denial of financial parity. Banks have wrongfully denied the parity between promissory notes and Federal Reserve notes as stipulated by law, leading to wrongful foreclosures and financial losses for borrowers. 7. Conspiracy to violate constitutionally secured rights. Judicial officers have been alleged to conspire with banks to systematically deprive the civilian population of their rights to property and fair commerce under the guise of legal proceedings. 8. Judicial collusion and unjust enrichment. There is an alleged collusion between judiciary members and financial institutions aimed at facilitating mortgage-backed securities schemes that unjustly enrich the involved parties. 9. Violation of due process in foreclosure proceedings. Banks and financial institutions have conducted foreclosure proceedings based on fraudulent misrepresentations of financial instruments, violating the secured due process rights of the affected homeowners. 10. Failure to provide just compensation. The government failed to provide just compensation for the seizure of gold as required by the Fifth Amendment, substituting it with financial instruments not equivalent in value, as they have reneged on the promise and ordeal to make eligible papers such as government contractual obligations, notes, drafts, bills of exchange, bankers' acceptances, trade acceptances, held to be at par with Federal Reserve notes and not enforcing the terms of the agreement with the American people, while others get to unjustly enrich themselves as a result of this systemic and intentional failure and breach of agreement. The New Deal must be held null and void as a result of the breach by government and financial institutions in their deal with the people during this ongoing national emergency and financial crisis. 11. Unconstitutional extension of emergency powers. The continued enforcement of emergency powers granted under the National Emergency Banking Act has led to sustained constitutional violations affecting civil liberties. 12. This act was passed without proper debate or adherence to legislative norms, and its provisions have been continuously misapplied or ignored by the government. 13. Inequitable handling of promissory notes. Financial institutions have mishandled promissory notes, treating them inconsistently with their legal status as money equivalents, leading to significant borrower detriment. 14. Fraudulent financial practices by banks. Banks have engaged in practices that create money from promissory notes beyond legal limits, constituting fraudulent financial practices. 15. Systemic financial deception. The systemic misrepresentation of the nature and value of financial instruments has perpetuated a broader financial deception impacting the national economy. 16. Unlawful seizure of property. The practices surrounding the handling and acknowledgement of financial instruments have led to unlawful seizures of property without proper legal grounds. 17. Misinformation and misapplication of financial laws. The Federal Reserve and banks have perpetuated misinformation regarding the legalities of financial instruments, misapplying laws to the detriment of borrowers. 18. Disregard for legal financial equivalence. The legal requirement for financial institutions to treat certain financial instruments at par with Federal Reserve notes has been routinely ignored. 19. Unconstitutional acts and statutes. Approximately 470 federal statutes derived from emergency powers are challenged as unconstitutional, having granted excessive powers to the executive branch. 20. Economic mislabeling of civilian population. The characterization of U.S. borrowers as economic liabilities in the face of systemic financial mismanagement by banks and government agencies is both incorrect and harmful. 21. Accountability for financial crisis. The financial institutions' practices have contributed to global financial crises, yet accountability has been insufficient and misdirected. 22. Legal obstruction and gatekeeping. Judicial and financial institutions have obstructed legal access and redress for affected civilian population, engaging in gatekeeping that violates legal and constitutional standards. 23. Demand for recompense. Plaintiffs demand compensation for wrongful foreclosures and financial malpractices that have led to personal and collective economic hardships. 24. Legal representation rights. The right of individuals to choose their legal representation, including non-attorney representation, has been unjustly restricted, violating constitutional provisions. 25. Transparency and accountability in financial record-keeping. There is a lack of transparency and accountability in how financial records and transactions are maintained and reported by financial institutions, necessitating corrective legal action. X. Affirmative relief demand. 1. Immediate stay on foreclosures. This lawsuit demands an immediate judicial order to stay all foreclosures related to loans where U.S. borrowers have petitioned for the issuance of Federal Reserve notes. As stipulated in Federal Reserve Operating Circular 10 Appendix 3. 2. Transparent financial accounting. The court is requested to mandate financial institutions involved in the issuance of loans tied to Federal Reserve notes to provide transparent and detailed accounting records for all related transactions. 3. Rectification and compensation. Compensation and rectification are sought for the misapplication of laws and financial regulations, leading to wrongful foreclosures, including substantial financial restitution for affected borrowers. 4. Declaratory relief. A declaratory judgment is sought confirming that approximately 470 federal statutes enacted under supposed emergency powers are unconstitutional due to granting excessive and unchecked powers to the executive branch. 470 federal statutes delegated to the President extraordinary powers, powers ordinarily exercised by Congress, conferring enough authority upon the President to rule this country without normal constitutional processes. 5. Disassembly of unconstitutional acts. The disassembly and invalidation of all laws and regulations derived from the National Emergency Economic Banking Relief Act, embracing the 470 unconstitutional federal laws and subsequent adhesive laws associated thereto, that have perpetuated constitutional violations and economic injustices are demanded. 6. Judicial review and overhaul. An overhaul and thorough judicial review of the processes by which financial instruments such as promissory notes and Federal Reserve notes are handled and recognized by financial institutions and courts are requested. 7. Prohibition of misrepresentation. An injunction is sought against financial institutions to prevent the misrepresentation of the legal and financial status of promissory notes and other similar instruments as non-equivalent to Federal Reserve notes. 8. Enforcement of legal financial parity. Enforcement of the legal requirement for financial institutions to treat promissory notes and similar financial instruments at par with Federal Reserve notes, as legally mandated, is demanded. 9. Accountability for economic mismanagement. This lawsuit seeks to hold financial institutions and regulatory bodies accountable for their roles in contributing to financial crises through misleading financial practices, demanding appropriate penalties and corrective actions. 10. Legal representation rights. The right of individuals to choose their legal representation, including non-attorney representation, is asserted, challenging any restrictions that violate constitutional principles. 11. Compensation for economic damages. Monetary compensation is claimed for the economic damages suffered by plaintiffs due to unlawful financial practices, including the problematic practices by banks in fractional reserve banking. 12. Return of unlawfully seized property. The return of, or compensation for, property unlawfully seized through wrongful foreclosure processes based on fraudulent financial practices is demanded. 13. Reform of judicial and financial practices. Comprehensive reform in judicial and financial sector practices is called for to ensure fairness, transparency, and adherence to constitutionally secured rights. 11. Trial by jury demand. 1. As regulated via the provisions of the Constitution of the United States of America, every individual is endowed with the unalienable right to a trial by jury. This constitutional guarantee is distinctly outlined in the 7th Amendment, which affirms the right to a trial by jury in all civil cases where the value in controversy exceeds $20. It is imperative to differentiate this from a jury trial, which is considered a statutory privilege rather than a fundamental right. 2. In asserting this constitutional guarantee, we hereby exercise our unequivocally secured right to a trial by jury and expressly elect to waive any privilege to a jury trial. This clarification is crucial as it underscores our demand for a trial by jury. adhering strictly to the terms set forth by the Seventh Amendment. 3. Should the court, either by assumption or presumption, impanel a jury, it is to be unequivocally recognized and construed as a trial by jury, and not as a jury trial. This distinction is vital, and our intent is hereby established on the record to ensure adherence to the constitutional mandate safeguarding our right. 12. Fractional reserve banking a capital gains. 1. Fractional reserve banking, legally sanctioned by congressional action, specifically through the enactment of the National Emergency Economic Banking Relief Act on March 9, 1933, permits financial institutions to engage in the issuance and management of Federal Reserve Bank notes, initially allowed until June 12, 1945. This act enabled banks to receive deposits and extend loans from these amounts under the guise of bailment, adhering to principles associated with this practice. 2. According to Title IV Section 401 subsection 18 paragraph 6 of the Federal Reserve Act, when a Federal Reserve bank or agent receives a promissory note, bill of exchange, draft, banker's acceptance, trade acceptance, or other government obligations, these instruments become their immediate obligation. Section 16, 2, and 4 of the same Act mandates that the Federal Reserve Board of Governors issues Federal Reserve notes to every U.S. borrower whose application is approved, ensuring that these notes equate to the total amount applied for, matching the par or face value of the promissory notes. 3. This constitutional process established by statute allows banks to engage in fractional reserve banking with what becomes their newfound property. However, for these assets to be legally considered the property of the banks, they must document the acceptance and correspondingly offset the accounts of the U.S. borrowers. Financial institutions are currently failing to substantiate or document this funding mechanism, and are fraudulently, as it appears from the records, claiming that there is an outstanding debt against borrowers. 4. The scheme of fractional reserve allows financial institutions to leverage as much as 90% of all deposits. Here, there are two distinct deposits involved: the promissory note received as collateral and security for the approved loan, and the Federal Reserve Board of Governors issuance of Federal Reserve notes on behalf of the borrower. Both are to be considered capital gains, yet remain untaxed. Additionally, the attachment of the note to a mortgage and its trading on the market constitutes a third deposit, allowing financial institutions to leverage their reserves a third time. A clear case of unjust enrichment, as the borrower's account is neither offset nor credited. 5. These gains, defined as capital gains, appear nowhere in corporate tax filings, suggesting potential tax evasion. If the law had been followed and the borrower's account compensated, there might exist a lawful mechanism allowing financial institutions to engage in these practices as part of their participation in a government program established by Congress. However, the absence of documentation for taxation on these gains and the fact that the Federal Reserve, being a private corporation, is not exempt from U.S. taxation, strongly suggests that these institutions are likely engaged in tax evasion. 13. Continuing emergency. 1. In 1973, the Senate Committee on the Termination of National Emergencies brought to light a critical and enduring issue concerning the national banking emergency initially declared by President Franklin Delano Roosevelt through Presidential Proclamation 2039. This declaration, rooted in the exigencies of the early 1930s financial crises, was intended as a temporary measure to stabilize a floundering banking system. During the Great Depression, however, the committee's findings revealed that the emergency status declared in 1933 was still active. implicating a prolonged state of emergency that has extended far beyond its original intent. 2. This ongoing emergency status has continuously enabled the application of extraordinary measures under the guise of emergency powers that were meant to be temporary. Such extended emergency powers have allowed for the continued use of practices and frameworks that were never intended to be permanent fixtures of American financial or legal systems. The perpetuation of this emergency poses significant questions regarding the balance of power, the scope of executive authority, and the implications for civil liberties and economic policies. 3. Legal and economic implications. Extended emergency powers. The protracted emergency status has allowed successive administrations to implement or maintain financial controls and measures that may not align with peacetime constitutional norms. This includes various forms of financial oversight and control mechanisms that could potentially infringe on economic freedoms and personal privacy. 4. Impact on financial regulations. The ongoing emergency has justified the continued use of expansive regulatory frameworks that affect the day-to-day operations of financial institutions and the economic rights of the American civilian population. These measures, while initially crafted in response to a so-called unprecedented economic collapse, have now become a semi-permanent overlay on the financial landscape of the United States. 5. Constitutional and legal challenges. The indefinite extension of emergency powers raises substantial constitutional issues, particularly concerning the separation of powers and the potential for executive overreach. It prompts a necessary reevaluation of the conditions under which emergency powers are invoked and sustained. 6. Demand for resolution. Given the historical context and the profound implications of an indefinitely prolonged national banking emergency, this lawsuit seeks the following. 7. A judicial review of the continued application of emergency powers initially granted during a specific historical crisis but extended indefinitely. 8. A declaratory judgment affirming the need to terminate such prolonged emergency status in accordance with constitutional principles and legislative intent. 9. Immediate steps to begin the normalization of legal and financial frameworks that have been unduly influenced by the extended state of emergency, ensuring that future economic policies and financial regulations adhere strictly to peacetime legal standards. 10. This section of the lawsuit emphasizes the necessity of addressing and resolving the prolonged national banking emergency to restore constitutional balance and economic normalcy. 14. Unjust enrichment. 1. Signature transformation. When a borrower signs a loan contract and mortgage, the document becomes a non-negotiable financial instrument, representing the agreed loan amount as its value. Citation: Carpenter v. Longin, 83 U.S. 271, 1872. The U.S. Supreme Court recognized that mortgages could be separated from the promissory notes they secure, treating the note as a non-negotiable instrument. 2. Asset creation non-disclosure. The bank fails to inform the borrower that their signature has created a valuable asset. Citation: TCF National Bank v. MKT Intelligence, Inc., 812 NW 2D 512. Min. Court. App. 2012. Discusses the duty to disclose material facts in transactions involving non-negotiable instruments. 3. Deposit of financial instrument. The borrower knowingly deposits this non-negotiable financial instrument with the bank, effectively turning over an asset. Citation: Lewis v. United States, 680 F.2d 1239, 9th CIR, 1982. explains the legal implications of depositing non-negotiable instruments in banking transactions. 4. Property ownership. Legally, since the borrower created the financial instrument through their signature, they retain ownership of it. Citation: Anderson v. Barnett Bank of South Florida, 884 So.2d 1003, Florida. Dist Court. App. 2004. Reinforces the concept that the creation of a non-negotiable financial instrument conveys ownership rights. 5. Liability non-disclosure. The bank does not disclose to the borrower that it has a liability equivalent to the value of the deposited non-negotiable financial instrument. Citation: Spelios v. BAC Home Loans Servicing, LP. Civil Action Number 11-11976, RWZ. 2013 WL 1245549. D. Mass. Mar. 26. 2013. Discusses the requirement for non-negotiable financial institutions to disclose liabilities and terms in loan transactions. 6. Receipt omission. The borrower does not receive any acknowledgement or receipt for the deposit of the financial instrument. Citation: J.P. Morgan Chase Bank, NAV. Traffic Stream, BVI. Infrastructure Limited, 536 U.S. 88, 2002, highlighting the importance of receipts and acknowledgments in non-negotiable financial transactions. 7. Creation of credit. The bank generates new money or credit on its books, which is credited against the borrower's financial instrument. Citation: Carpenter v. Longan, 83 U.S. 271, 1872. While primarily about the non-negotiability of instruments, it touches on the implications of creating obligations through banking practices. 8. Misrepresentation of created money. The bank does not disclose that the borrower's signature essentially created new money, which the bank then claims to loan back to the borrower. Citation: Jesenowski v. Countrywide Home Loans, Inc., 574 U.S. 259, 2015, discusses the rights of borrowers under the Truth in Lending Act, which includes the right to rescind non-negotiable transactions due to non-disclosure. 9. Credit as loan. The money credited to the borrower's account is misleadingly referred to as a loan rather than an exchange for the non-negotiable deposited asset. Citation: Rivera v. Wells Fargo Bank, N.A. No. C1200423 WA. 2012 WL 2343926. ND Cal. June 20, 2012. Discusses the legal distinction between non-negotiable true loans and extensions of credit. 10. Misnomer of banking practices. The overall process is misrepresented to the public as mortgage lending or loan issuance. 11. Citation: Ramirez v. Greenpoint Mortgage Funding, Inc., No. 09 CV 2050 BTM, NLS. 2010 WL 2998309. SD Cal. July 29, 2010. Deals with misrepresentations in non-negotiable mortgage lending disclosures. 12. Citation: Jesenowski v. Countrywide Home Loans, Inc., 574 U.S. 259, 2015, reinforces the necessity of accurate disclosure under the Truth in Lending Act, pertinent when a bank characterizes non-negotiable credit extensions inaccurately. 13. 14. Citation: Ramirez v. Greenpoint Mortgage Funding, Inc., No. 09 CV 2050 BTM, NLS. 2010 WL 2998309. SD Cal. July 29, 2010, focuses on the Requirements for accurate and truthful representations in non-negotiable mortgage disclosures. 15. 16. Citation. Barber v. American Express Company. 802 F. Sup. 2D 1045. SD Cal. 2011. Discusses unjust enrichment claims when no actual value is provided in non-negotiable financial transactions. 17. 18. Citation. Credit River Township v. Mirsky. 1969. Justice Martin V. Mahoney. Although not a binding precedent, it famously proffered that a bank did not provide real consideration, i.e., funding as defined in the agreement and in law, and a non-negotiable contract was formed. 19. 20. Citation. First National Bank of Montgomery v. Jerome Daly. 1969. Justice Martin V. Mahoney. The Credit River case. Was not this an obscure matter? This case had the bank manager well experienced under cross-examination before court produce testimony that is hereby incorporated into this matter, explaining how fractional reserve banking and unconstitutional practice actually operates. The issue of what constitutes consideration and the reality of money creation in banking is of course foundational. 21. Citation. Universal v. Bank of America. 2010 WL 2507767. Cal. App. Debit Super. Court. 2010. Explores the fiduciary misrepresentations and the role of the borrower as creditor in credit creation. 22. 23. Citation. Carpenter v. Longan. 83 U.S. 271. 1872. Supports claims regarding the sale and separation of a note and its securing mortgage, potentially relevant to the sale of non-negotiable financial instruments. 24. Citation. Merrill Lynch. Pierce. Fenner and Smith Inc. v. Dabbitt. 547 U.S. 71. 2006. While primarily concerning securities fraud, this case can illustrate the legal recognition of the intrinsic value of financial instruments. 25. 26. Citation. Lancaster v. Buerger. 2012 WL 2405197. ND-IL. June 26, 2012. Discusses the conversion of non-negotiable loan documents into securities and the legal implications of such actions. 15. Appearance of RICO, fraud, conspiracy, FACILITA ting a legal process. 1. The judicial, legislative, and executive branches have been complicit in allowing financial institutions to initiate foreclosure proceedings under deceptive conditions. These actions are facilitated by a systemic failure to enforce the requirement for plaintiffs, namely the financial institutions, to substantiate their claims of outstanding debt with concrete evidence of financial loss. 2. Lack of proof of claim. Financial institutions have regularly failed to provide concrete proof that the original deposits could not be offset through fractional reserve banking as allowed by law, specifically under Title IV of the Federal Reserve Act, Section 401 subsection 18 paragraph 6, and Section 403. These sections clearly define promissory notes, drafts, bills of exchange, and bankers' acceptances, especially when accompanied by the Federal Reserve Operating Circular No. 10 Appendix 3, as collateral and security for Federal Reserve notes. 3. Misrepresentation in court. By initiating foreclosure claims without the requisite proof of an unfulfilled debt, given that the debt was lawfully settled upon the submission and acceptance of the promissory note as a deposit, these institutions engage in the dissemination of false and misleading information, This conduct not only misrepresents the financial status of the defendant but also places fraudulent claims into the public record, an act that constitutes felony. Under U.S. law. 4. Judicial oversight and complicity. The courts have neglected their duty to scrutinize these claims adequately, often disregarding the legal requirement that the burden of proof lies with the plaintiff. Instead, they place the onus on the defendant to disprove allegations made by the plaintiff. Contrary to the fundamental legal principle that a plaintiff must substantiate every claim in their complaint. 5. Systemic misrepresentation for profit. The actions of these financial institutions, facilitated by court procedures that fail to challenge their assertions, appear to be driven by motives of financial gain through unjust enrichment. This systemic misrepresentation of legal and financial processes not only undermines the integrity of the judicial system but also inflicts significant harm on individuals who are unjustly subjected to foreclosure. 6. Demand for judicial integrity and reform. We demand immediate reform in judicial handling of foreclosure cases, requiring strict adherence to proof of claim standards and the proper placement of the burden of proof on financial institutions claiming debt obligations. Furthermore, any financial institution found to be deliberately misrepresenting information for profit should face stringent penalties. We seek a judicial declaration to rectify these malpractices and restore fairness and transparency in the legal process surrounding foreclosures. 16. In excess of possible unconstitutional 470 federal statute that violate the non-delegation of authority doctrine. 1. Background and findings of the Senate Committee. A. In 1973, the Senate Committee on the Termination of National Emergencies conducted an exhaustive review and identified 470 federal statutes that unconstitutionally granted extensive legislative powers to the President of the United States. These statutes, collectively, endowed the President with enough authority to govern the country independently of the mandated constitutional processes, effectively bypassing the designed checks and balances. This concentration of power was deemed to contravene the non-delegation doctrine, which holds that Congress cannot delegate its legislative powers to another branch of government without clear and precise standards. B. Congressional actions and omissions. C. Despite the committee's findings, these statutes remained active. In response, Congress passed the National Emergency Act in 1976, aiming to curb the executive's unchecked powers exercised under the guise of national emergencies. However, this act did not address the repeal of the 470 statutes, allowing the continued unconstitutional delegation of legislative power to the executive. This ongoing oversight reflects a significant failure by Congress to align federal statutes with constitutional requirements. D. Legal and constitutional implications. The unchecked powers granted by these statutes allow governance akin to martial law, concentrating significant authority under the executive's discretion, specifically framed within the President's role as the Commander-in-Chief of the Armed Forces. This arrangement distorts the balance of power and infringes upon the rights of American civilians, impacting their lives in profound and extensive ways. E. Congressional acknowledgement and judicial review. The enactment of the National Emergency Act of 1976 by Congress was a direct acknowledgement of the unconstitutional nature of these statutes, as highlighted by the Senate Committee. Yet, the lack of decisive action to repeal these statutes constitutes a continued violation of constitutional principles. F. Request for judicial intervention. A judicial ruling is now imperative to address the following. 1. The legality of the continued enforcement of the 470-plus statutes identified as unconstitutional. 2. The constitutionality of delegating such extensive legislative powers to the executive branch. 3. The effectiveness and alignment of the National Emergency Act of 1976 with constitutional standards in rectifying the issues identified by the Senate Committee. G. This lawsuit seeks to challenge the constitutionality of these statutes and to compel the legislative and executive branches to conform to constitutional requirements, thereby restoring the intended separation of powers and protecting the constitutionally secured rights of American civilians. 17. Compensatory damages claim. 1. This lawsuit seeks compensatory damages in the amount of $400 billion. $400 billion adjusted for inflation and devaluation. This claim reflects the profound and ongoing deprivation suffered by private American civilians due to actions of financial institutions which, despite engaging in a fractional reserve banking scheme, claimed to be on the brink of bankruptcy and received taxpayer-funded bailouts. These funds were ostensibly claimed necessary to prevent their collapse during the financial crisis, even as they continued to perpetrate financial fraud on a massive scale against the American people. None of the funds may come from taxpayers' dollars. Fractional reserve banking may be offset by any means and cannot be passed on to taxpayers under any circumstances. Any claims against United States is not for monetary damages whatsoever. The Federal Reserve Bank, the Federal Reserve Board, are the parties liable for monetary damages. 2. The damages sought to account for the loss of livelihood, homes, property, and the fundamental right to redress. Additionally, compensation is sought for the emotional and psychological distress suffered by individuals, including anguish, embarrassment, and significant damage to their credit, reputation, and public image. 3. Definition of torture. Torture is defined as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or her or a third person information or a confession, punishing him or her for an act he or she or a third person has committed or is suspected of having committed, or intimidating or coercing him or her or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. United Nations Convention Against Torture. 4. The $400 billion in damages is intended to establish a special fund managed by the Aeon Foundation, operating as the conservator. This fund will ensure that those disenfranchised individuals are duly compensated at 120% of the highest rated value of their property over a 25-year period. This approach not only seeks to redress past harms but also to provide a sustainable financial framework to support the recovery and stability of affected individuals. 5. The jury, to be impaneled under the constitutional protections afforded by the 7th Amendment, will determine the extent to which these actions constitute torture and other violations under the definitions provided. This determination will guide the appropriate allocation and distribution of the compensatory damages. 18. Punitive damages claim. 1. This lawsuit seeks not only compensatory redress but also punitive measures against the defendants to prevent future misconduct and to penalize for past actions. The punitive damages $200 billion as stipulated herein aim to rectify the systemic abuses observed and to institute reforms that ensure transparency and accountability in banking practices. The following measures are demanded. 2. Prohibition on unnotified fractional reserve banking. Defendants are henceforth prohibited from engaging in fractional reserve banking without explicitly notifying the borrower each time such practices affect the borrower's account or are related to the borrower's transactions. This notification must include detailed information on how fractional reserve practices impact the specific financial instruments and accounts of the borrower. 3. Mandatory cash method accounting. Defendants must adopt and maintain a cash method of accounting for all transactions involving borrowers to ensure clarity and simplicity in financial reporting. This requirement is intended to make the financial activities comprehensible to borrowers, who must be able to easily understand and verify the financial statements and transactions affecting their accounts. 4. Validation and verification of accounting. All accounting provided to borrowers must be comprehensive and must be validated and verified through a declaration or affidavit signed by an individual with the requisite capacity and expertise to provide such information. This step is crucial to ensure the accuracy and legitimacy of the financial statements provided to borrowers. 5. Repayment of fractional reserves. Defendants are required to return all profits accrued from fractional reserve banking related to any account where fraud has been alleged and no proof of funding has ever been provided by the financial institution. These funds should be returned to the American taxpayer, i.e., the borrower, and the Social Security account of all affected Americans and applied directly to the national debt of the United States in a dollar-for-dollar repayment scheme. This measure is intended to directly address and mitigate the financial impact of the defendants' fraudulent activities on the nation's economy. 6. Jury evaluation of evidence and fraud. The determination of fraud and the evaluation of the evidence presented are to be decided by a jury impaneled under the constitutional protections afforded by the 7th Amendment. This jury will assess whether the defendant's actions constitute fraud as demonstrated by the record and decide on the appropriateness and extent of the punitive damages. 7. This lawsuit seeks to establish stringent requirements for financial transactions and contracts involving borrowers to ensure fairness, transparency, and genuine consent. Given the historical abuses and the deceptive practices identified, the following measures are urgently demanded. 8. Consent for trading financial instruments. No trading of a borrower's financial instruments on any market shall occur without their explicit written consent. This measure ensures that borrowers maintain control over their financial assets and are fully aware of and agree to any potential use of their instruments in financial markets. 9. Elimination of adhesion contracts and legalese. All contracts between borrowers and financial institutions, including any members of the Federal Reserve Banks and the Federal Reserve System, must be written in clear, straightforward language that the borrower can easily understand. The use of complex legal terminology, or legalese, designed to obscure the true nature of the obligations being agreed to, is strictly prohibited. 10. Detailed contract explanations. If a contract is more than 3 single-sided pages in length, the financial institution must provide a detailed explanation of each clause. This explanation must be documented, with the borrower acknowledging in writing that they understand each section of the contract. This requirement is intended to prevent misunderstandings and ensure informed consent. 11. Dual signatures on contracts. No unilateral contracts with borrowers will be permitted. All contracts must include the signatures of both the financial institution and the borrower, underscoring the mutual agreement and understanding regarding the terms of the contract. 12. Arbitration clause requirements. Each contract must include an arbitration clause offering a choice of 10 separate alternative dispute resolution agencies. At least 5 of these must be independent arbitration associations with no affiliations to the financial institution. This provision ensures that borrowers have access to fair and impartial mediation and resolution services. 13. Reform of foreclosure practices. Courts are prohibited from utilizing expedited processes to facilitate foreclosures based on financial institutions' claims of losses, especially when such losses are not demonstrably evident on the record. This change is necessary to protect borrowers from unjust loss of property and to ensure that foreclosure processes are conducted transparently and only when genuinely warranted. 14. These reforms are proposed to rectify the power imbalances in financial transactions and to protect borrowers from predatory practices that have led to significant personal and financial hardships. By enforcing these measures, the lawsuit aims to restore integrity to financial dealings and ensure that all contractual relationships are conducted on a basis of informed consent and mutual respect. 15. These punitive measures are proposed to ensure that the defendants cannot continue to engage in deceptive practices without immediate and tangible consequences. By imposing strict oversight and rigorous financial penalties, this lawsuit aims to restore trust and integrity in financial transactions and to uphold the rights and interests of American borrowers. 19. Matters for a jury to decide. 1. Whether the defendants engaged in unjust enrichment through fractional reserve banking practices. Case reference: Kumho Tire Co. v. Carmichael, 526 U.S. 137, 1999, emphasized the jury's role in determining the application of expert testimony, which can be analogous to complex banking practices. 2. If the defendants misrepresented the nature of financial instruments to borrowers. Case reference: Bridge v. Phoenix Bond and Indem Co. 553 U.S. 639, 2008, highlighted that the determination of fraud is typically a question for the jury. 3. Whether the loan agreements constituted adhesion contracts due to their complexity and the imbalance of power. Case reference: Williams v. Walker Thomas Furniture Company, 350 F.2d 445, DCCIR 1965, dealt with unconscionable contracts, often a jury question regarding fairness and understanding. 4. If explicit consent was obtained for trading financial instruments on markets. Case reference: Securities and Exchange Commission v. Ginsburg, 362 F.3d 1292, 11th CIR, 2004, involved securities fraud where jury decided on the matter of misleading investors. 5. Whether the disclosure requirements were adequately met by financial institutions. Case reference: TSC Industries, Inc. v. Northway, Inc. 426 U.S. 438, 1976. The standard for materiality in disclosure. A common jury question. 6. If the charges of interest and fees were justified given the nature of the financial transactions. Case reference: Pavlov v. Bank of America Corp. 135 S. Court. 1194. 2015. Addressed fees in banking. A potential jury issue. 7. Whether the use of legalese in contracts effectively obscured critical information from borrowers. Case reference: Huff v. Regions Financial Corporation, 5F.3d 491, 11th CIR, 1993, considered the clarity of contract terms. 8. The legality of the foreclosure processes used by financial institutions. Case reference: Wells Fargo Bank, Na v. Farmer, 867 NYS 2D21. App. Div. 2008. Foreclosure practices scrutinized. Often a jury matter. 9. If the fractional reserve banking was disclosed to borrowers in a transparent manner. Case reference. FDIC v. Hamilton. 122 F.3d 854. 9th CIR. 1997. Dealt with disclosures in banking practices. 10. Whether the contracts signed were bilateral with full understanding and agreement from both parties. Case reference. Carnival Cruise Lines, Inc. v. Shoot. 499 U.S. 585. 1991. Considered contract terms and the extent of mutual agreement. 11. The extent of emotional and financial distress caused to borrowers due to the alleged fraudulent practices. Case reference. State Farm Mutual Automobile Insurance Co. v. Campbell. 538 U.S. 408. 2003. Examined punitive damages related to distress. A matter for the jury. 12. If the sale of financial instruments was conducted with the proper legal authority and consent. Case reference. Stoneridge Investment Partners, LLC v. Scientific Atlanta, Inc. 552 U.S. 148. 2008. Related to third-party responsibilities in securities. Often decided by juries. 13. The impact of non-disclosure of financial terms on the overall understanding of borrowers. Case reference. Basic Inc. v. Levinson. 485 U.S. 224. 1988. Considered the impact of misinformation. A typical jury question. 14. Whether the profits from the sale of financial instruments were unlawfully retained by financial institutions without due compensation to borrowers. Case reference. Phillips v. AWH Corp. 415 F.3d 1303. Fed. CIR. 2005. Intellectual Property and Profits. Relevant to financial instruments. 15. The accuracy and fairness of credit reporting by financial institutions post-transaction. Case reference. Spears v. First American E-Appraise IT. 843 F. Sup. 2D 981. ND Cal. 2012. Addressed issues of accurate reporting. A jury matter. 16. Whether the arbitration clauses included in financial agreements were fair and impartial. Case reference. AT&T Mobility LLC v. Concepcion. 563 U.S. 333. 2011. Reviewed the fairness of arbitration agreements. 17. The role of the financial institution as a fiduciary and whether it breached its fiduciary duty. Case reference. Burke v. PricewaterhouseCoopers LLP Audit. 572 F.3d 76. 2nd CIR. 2009. Fiduciary duties and breaches. Typically decided by juries. 18. The legal validity of using taxpayer money for bailouts without demonstrable necessity. Case reference. Star International Co. v. United States. 856 F.3d 953. Fed. CIR. 2017. Considered the legality of government bailouts. 19. If financial losses claimed by banks were substantiated by actual financial records. Case reference. Lilly v. State Street Bank and Trust Company. 538 F.3d 23. First CIR. 2008. Addressed the necessity of substantiating financial claims. 20. The degree to which financial institutions followed federal and state laws in their dealings with borrowers. Case reference. United States v. Countrywide Financial Corp. 642 F.3d 70. 2nd CIR. 2011. Addressed adherence to laws in mortgage lending. 21. Whether the defendants engaged in unjust enrichment through fractional reserve banking practices. Case reference. Kumho Tire Co. v. Carmichael. 526 U.S. 137. 1999. Emphasized the jury's role in determining the application of expert testimony, which can be analogous to complex banking practices. 22. If the defendants misrepresented the nature of financial instruments to borrowers. Case reference. Bridge v. Phoenix Bond and Indem. Co. 553 U.S. 639. 2008. Highlighted that the determination of fraud is typically a question for the jury. 23. Whether the loan agreements constituted adhesion contracts due to their complexity and the imbalance of power. Case reference. Williams v. Walker Thomas Furniture Company. 350 F.2d 445. DCCIR. 1965. Dealt with unconscionable contracts. Often a jury question regarding fairness and understanding. 24. If explicit consent was obtained for trading financial instruments on markets. Case reference. Securities and Exchange Commission v. Ginsburg. 362 F.3d 1292. 11th CIR. 2004. Involved securities fraud where jury decided on the matter of misleading investors. 25. Whether the disclosure requirements were adequately met by financial institutions. Case reference. TSC Industries, Inc. v. Northway, Inc. 426 U.S. 438. 1976. The standard for materiality in disclosure. A common jury question. 26. If the charges of interest and fees were justified given the nature of the financial transactions. Case reference. Pavlov v. Bank of America Corp. 135 S. Court. 1194. 2015. Addressed fees in banking. A potential jury issue. 27. Whether the use of legalese in contracts effectively obscured critical information from borrowers. Case reference. Huff v. Regions Financial Corporation. 5F.3d 491. 11th CIR. 1993. Considered the clarity of contract terms. 28. The legality of the foreclosure processes used by financial institutions. Case reference. Wells Fargo Bank. Na v. Farmer. 867 NYS 2D 21. App. Div. 2008. Foreclosure practices scrutinized. Often a jury matter. 29. If the fractional reserve banking was disclosed to borrowers in a transparent manner. Case reference. FDIC v. Hamilton. 122 F.3d 854. 9th CIR. 1997. Dealt with disclosures in banking practices. 30. Whether the contracts signed were bilateral with full understanding and agreement from both parties. Case reference. Carnival Cruise Lines, Inc. v. Shoot. 499 U.S. 585. 1991. Considered contract terms and the extent of mutual agreement. 31. The extent of emotional and financial distress caused to borrowers due to the alleged fraudulent practices. Case reference. State Farm Mutual Automobile Insurance Co. v. Campbell. 538 U.S. 408. 2003. Examined punitive damages related to distress. A matter for the jury. 32. If the sale of financial instruments was conducted with the proper legal authority and consent. Case reference. Stoneridge Investment Partners, LLC v. Scientific Atlanta, Inc. 552 U.S. 148. 2008, related to third-party responsibilities in securities, often decided by juries. 33. The impact of non-disclosure of financial terms on the overall understanding of borrowers. Case reference: Basic Inc. v. Levinson, 485 U.S. 224, 1988, considered the impact of misinformation. A typical jury question. 34. Whether the profits from the sale of financial instruments were unlawfully retained by financial institutions without due compensation to borrowers. Case reference: Phillips v. AWH Corp. 415 F.3d 1303. Fed. CIR. 2005. Intellectual Property and Profits. Relevant to financial instruments. 35. The accuracy and fairness of credit reporting by financial institutions post-transaction. Case reference: Spears v. First American E-Appraise IT. 843 F. Sup. 2D 981. ND Cal. 2012. Addressed issues of accurate reporting. A jury matter. 36. Whether the arbitration clauses included in financial agreements were fair and impartial. Case reference: AT&T Mobility LLC v. Concepcion. 563 U.S. 333. 2011. Reviewed the fairness of arbitration agreements. 37. The role of the financial institution as a fiduciary and whether it breached its fiduciary duty. Case reference: Burke v. PricewaterhouseCoopers LLP Audit. 572 F.3d 76. Second CIR. 2009. Fiduciary duties and breaches. Typically decided by juries. 38. The legal validity of using taxpayer money for bailouts without demonstrable necessity. Case reference: Star International Co. v. United States. 856 F.3d 953. Fed. CIR. 2017. Considered the legality of government bailouts. 39. If financial losses claimed by banks were substantiated by actual financial records. Case reference: Lilly v. State Street Bank and Trust Company. 538 F.3d 23. First CIR. 2008. Addressed the necessity of substantiating financial claims. 40. The degree to which financial institutions followed federal and state laws in their dealings with borrowers. Case reference: United States v. Countrywide Financial Corp. 642 F.3d 70. Second CIR. 2011. Addressed adherence to laws in mortgage lending. XX. Summarization. 1. Unconstitutional statutes and emergency powers. It's proffered that 470 federal statutes have unconstitutionally delegated extensive legislative powers to the president, allowing governance beyond normal constitutional processes. Despite recognition of these issues in the National Emergency Act of 1976, these statutes remain active. 2. Fractional reserve banking and deception. The complaint alleges that financial institutions engage in fractional reserve banking without transparent disclosure, misleading borrowers about the nature and implications of financial instruments and transactions. 3. Contractual misconduct. Contracts are often presented in complex legal language. Legalese lack transparency and are not thoroughly explained to borrowers, which obscures the terms and undermines informed consent. The complaint demands that all contracts be clear, concise, and fully explained, with dual signature requirements to ensure mutual agreement. 4. Foreclosure abuses. The lawsuit claims that financial institutions wrongfully initiate foreclosures without adequate proof of the borrower's actual default or financial loss. often expedited by the courts without proper scrutiny. 5. Misrepresentation of financial products. Institutions are accused of falsely labeling created credit as loans, charging unwarranted interest and fees without providing equivalent value, and misrepresenting borrowers as debtors when they are, in fact, creditors. 6. Compensatory and punitive damages. The complaint seeks $40 billion in compensatory damages for deprivation of property, livelihood, and legal redress, alongside emotional distress. Additionally, punitive measures are requested to reform banking practices, including mandatory detailed disclosures and the cessation of deceptive financial reporting. 7. Trading and securitization without consent. Financial instruments related to borrowers are traded and securitized without their explicit consent, often resulting in profits that are not shared with or disclosed to the creators of these instruments. 8. Lack of proper accounting and transparency. Financial institutions are called to account using a cash method rather than accrual. To ensure transparency, each transaction must be clearly documented and verified by qualified personnel. 9. Arbitration and legal proceedings. The complaint asserts that all financial agreements should include fair arbitration clauses, providing multiple independent options for dispute resolution. It also criticizes the current handling of foreclosures and demands that courts require concrete evidence of debt and damages before proceeding. 10. Return of unjust gains. It is demanded that all profits derived from fractional reserve banking be returned to the American taxpayers to reduce the national debt, rectifying the financial exploitation documented. 11. Jury determination. The complaint emphasizes that many of the allegations, particularly those involving interpretations of law and determinations of fact, such as the presence of fraud or the adequacy of disclosures, should be decided by a jury under the Seventh Amendment protections. Overall claim. The overarching claim is that through a combination of unconstitutional legislation, deceptive banking practices, and coercive contract terms, financial institutions have systematically exploited borrowers. This exploitation is supported and exacerbated by inadequate regulatory oversight and judicial processes that fail to safeguard borrower rights. The lawsuit seeks not only financial redress but also structural changes to prevent future abuses and restore fairness and transparency to the banking system. 21. Certification, validation, verify cation. The aforementioned is wholly accurate and done under the authority created by virtue of the contract between the parties. The Aeon Foundation is a private nonprofit trust foundation organization, receiving the power of attorney from each of its sole proprietorship clients. The aforementioned information incorporates the personal experiences of the sole proprietor, is based on first-hand knowledge, facts and/or information, and is wholly accurate, attested, declared, sworn, and stated as such. It is witnessed by and before God under penalty if held otherwise. A copy of the aforementioned parties either through United States Postal Service and/or other means, whereby waiver has authorized on or about this the 22nd day of May 2024. So help me God. Additional plaintiffs. Last name. First name. Dash. Each plaintiff stands before this court v. Special_visitation. Sui juris and none shall be construed as a p-gearing and/or having the capacity of a FIGAF person. FIGAF fiction. Legal name. Legal entity. Instrumentality of any state. Each represents their own individual estate but are exercising their secured right to stand before the court in their natural capacities. Additional defendants operating under the authority of the U.S. government, either through the United States Federal Reserve or the United States Attorney General's Office via the various Secretaries of State, 1. Cuyahoga County Treasurer. ETLW. Christopher Murray. 2. COPRORATE Headquarters. 2079 Fast 9th Street, Cleveland, Ohio, 441151302. 2. Cuyahoga County Executive. Et al. Armand Buddish. COPRORATE Headquarters. 2079 East 9th Street, Cleveland, Ohio, 441151302. 3. Carlisle, McNelly, Reaney, Kramer and Ulrich, Colorado, LPAET, Al. Maureen Zinkdelen COPRORATE Headquarters. 24755 Chagrin Boulevard, Suite 200 Beechwood, Ohio, 441225690. 4. Fig Capital Investments. UC. Et al. Gustavo Bartol. COPRORATE Headquarters. 1000 Riverside Avenue, Suite 400 Jacksonville, Florida, 3220441008. 5. Cuyahoga County Clerk of Courts. Et al. Nyla K. Bird. COPRORATE Headquarters. 1200 Ontario Street, Cleveland, Ohio, 441131604. 6. Cuyahoga County Court of Common Pleas General Division Magistrate Gina Lunsford. COPRORATE Headquarters. 6th floor of Courthouse Square 310W. Lakeside Avenue, Cleveland, Ohio, 441131604. 7. Cuyahoga County Court of Common Pleas General Division Judge Maureen Clancy. COPRORATE Headquarters. Justice Center 1200 Ontario Street, Room 20B, Cleveland, Ohio, 441131604. 8. Amerigroup Mortgage Corporation. Et al. Jeffrey J. Crilly. COPRORATE Headquarters. 6090 Central Avenue, St. Petersburg, Florida, 337071622. 9. Chase Bank. Second Mortgage. Jamie Dimon. COPRORATE Headquarters. 270 Park Avenue. Floor 12, New York, New York, 100172036. 10. Midland Mortgage Co. E.T. Al. Ken Clark. COPRORATE Headquarters. 999 Northwest Grand Boulevard, Oklahoma City, Oklahoma, 731186051. 11. MidFirst Bank. E.T. Al. G. Jeffrey Records? Jr. COPRORATE Headquarters. 2730 North Portland Avenue, Oklahoma City, Oklahoma, 731071508. 12. Freedom Mortgage Corporation. E.T. Al. Stanley C. Middleman. COPRORATE Headquarters. 951 Yamato Road, ST 175, Boca Raton, Florida, 33431. 13. JPMCP Chase. E.T. Al. Jamie Dimon. COPRORATE Headquarters. 270 Park Avenue. Floor 12, New York, New York, 100172036. 14. Navy Federal Credit Union, Mary McDuffie. COPRORATE Headquarters. 820 Fallen Lane, SE Vienna, Virginia, 2218049007. 15. Mahela Department of Education. COPRORATE Headquarters. 633 Spirit Drive. Scott D. Giles. Chesterfield, Missouri, 630051243. 16. Wells Fargo Bank NA. Et al. Charles W. Scharf. COPRORATE Headquarters. 420 Montgomery Street, San Francisco, California, 94104. 17. Golden One Credit Union. et al. Donna Bland, COPRORATE Headquarters. 8945 Cal Center Drive, Sacramento, California, 95826. 18. Thurston County Superior Court, Building 3 et al. Judge Lanese, COPRORATE Headquarters. 2000 Lakeridge Drive, SW Olympia, Washington, 985026042. 19. Bank of America Corporate Center, et al. Bryant, Moynihan, COPRORATE Headquarters. 100 North Tryon Street, Charlotte, North Carolina, 282554000. 20. Small Business Administration, et al. Sabella Casillas Guzman, COPRORATE Headquarters. 409 3rd STSW, Washington, District of Columbia, 20416. 21. U.S. Department of Education, et al. Secretary of Education Miguel Cardona, COPRORATE Headquarters. 400 Maryland Avenue, SW Washington, District of Columbia, 20202. 22. New Jersey American Water Company, Inc., et al. Subsidiary of American Water WROKDS Company Inc. Susan Hardwick, COPRORATE Headquarters. FUPDATE Parent CO. Corporate, 1 Water Street, CAMBDENNJ, 08102-1658, was 294 Route 31, Washington, New Jersey, 07882, Camden, New Jersey, 081021658. 23. NationStar Mortgage DBA, Mr. Cooper, J. Bray, COPRORATE Headquarters. 8950 Cypress Waters Boulevard, Coppell, Texas, 75109. 24. First Bank D.B., a First Bank Mortgage Mikel Williamson, COPRORATE Headquarters. Corporate Move, 11901 Olive Boulevard, Creve Coeur, Missouri, 631416736. Was First Missouri Center, 114 Street, Lewis, Missouri, 631416736. 25. School First Federal Credit Union Bank, et al. Bill Cheney, COPRORATE Headquarters. 15332. Newport Avenue, Tustin, California, 92.7806408. 261 Lakeview Loan Servicing UC, et al. Julio Aldacacia, COPRORATE Headquarters. 4425 Ponce de Leon Boulevard, MSS 251 CORAL Gables, Miami, Florida, 331641837. 27. American Honda Financial Corporation, Giro MORISAWA President, COPRORATE Headquarters. 1919 Torrance Boulevard, Torrance. 28. 21st Mortgage Corporation, Tim Williams, COPRORATE Headquarters. 620 Market Street, Knoxville, California, 90501. 29. MNTBANK, et al. Renee F. Jones, COPRORATE Headquarters. 1 M&T Plaza, Buffalo, New York, 142032308. 30. Sensible Auto Lending LLC, Jason Friedland, COPRORATE Headquarters. 26 Mill Payne Road, Suite 2D, Danbury, Connecticut, 068115186. 31. Santander Consumer USA Holdings Inc., et al. Bruce Jackson, COPRORATE Headquarters. 1601 Elm St. Suite 800, Dallas, Texas, 752017260. 32. Kane and Wiener, E.T. Al. Greg Cohen, COPRORATE Headquarters. 5B05 Sepulveda Boulevard 4th floor Sherman Oaks, California, 914112532. 33. CKS Prime Investments UC, E.T. Al. Jack C. Kleinert, COPRORATE Headquarters. 1800 State Route 34 Suite 305C Blodge 3 Wall Township, New Jersey, 077199168. 34. United States Department of Treasury Janet Yellen, COPRORATE Headquarters. 1500 Pennsylvania Avenue, Northwest Washington, District of Columbia, 20003. 35. United States Department of Justice, ETL. Attorney General Merrick 8, Garland, COPRORATE Headquarters. 950 Pennsylvania Avenue, NWWASHINGTON, District of Columbia, 20350. 36. Nova Financial Investment Corporation, E.T. Al. Ryan Vondrick, COPRORATE Headquarters. 6245 East Broadway, Suite 400, Tucson, Arizona, 857114029. 37. Wells Fargo Home Mortgage, E.T. Al. Charles W. Scharf, COPRORATE Headquarters. 420 Montgomery Street, San Francisco, California, 94104. 38. J.P. Morgan Chase, E.T. Al. Jamie Dimon, COPRORATE Headquarters. 270 Park Avenue, Floor 12, New York, New York, 100172036. 39. SN Servicing Corporation Robin P. Arkley, COPRORATE Headquarters. 13702 Coursey Boulevard Building, Le Baton Rouge, Louisiana 70817. 40. PHH Mortgage Services, E.T. Al. Glen A. Messina, COPRORATE Headquarters. 3000 Leadenhall Road, MT. LaRue, New Jersey, 080544606. 41. Center County Courthouse, et al. Clerk of Court Jeremy S. Brian, COPRORATE Headquarters. 102 SA, Fagany Street, Bellefonte, Pennsylvania, 168231983. 42. Supreme Court of the Commonwealth of Pennsylvania, et al. Amy Drybilbis, Esquire, Deputy Prothonotary, COPRORATE Headquarters. Pennsylvania Judicial Center, 601 Commonwealth Avenue, Suite 4500, Harrisburg, Pennsylvania, 171200902. 43. The General Assembly of the Commonwealth of Pennsylvania, et al. COPRORATE Headquarters. 501 North 3rd Street, Harrisburg, Pennsylvania, 171200302. 44. Governor of Pennsylvania Tom Wolf, COPRORATE Headquarters. 508 Main Capitol Building, Harrisburg, Pennsylvania, 171200022. 45. Secretary of Defense et al. James N. Mattis, COPRORATE Headquarters. 1000 Defense Pentagon Room 3E, 880 Washington, District of Columbia, 203011000. 46. Lakeview Loan Servicing, E.T. Al. Julio Aldacacia, COPRORATE Headquarters. 4425 Ponce de Leon Boulevard, Mississippi, 5-251 Coral Gables, Miami, Florida, 331461837. 47. Freedom Mortgage Corporation, E.T. Al. Stanley C. Middleman COPRORATE Headquarters. 907 Pleasant Valley Avenue, Suite 3MT, Laurel, New Jersey, 08054. 48. Loan Depot, E.T. Al Frank Martel, COPRORATE Headquarters. 26642 Town Center, Dr. Foothill Ranch, California, 92610. 49. PennyMac Loan Services, LLC, David A. Spector, COPRORATE Headquarters. 3043 Townsgate Road, STE. 200 Westlake Village, California, 913613027. 50. PHH Mortgage Services, E.T. Al. Glen A. Messina, COPRORATE Headquarters. 3000 Leadenhall Road, MT. Laurel, New Jersey, 080544606. 51. Loandapot, Com. LLC TEXAS Division. Et. Al. Frank Martel, COPRORATEHEADQUARTERS. 26642 Town Center Drive, Foothill Ranch, California, 926102808. 52. Fayette County Sheriff's Office, Randall Johnson Law Enforcement Center. Et al. Sheriff's Office, Chad Chadwell, COPRORATE Headquarters. 155 Johnson Avenue, Fayetteville, Georgia, 30214. 53. San Bernardino County Child Support. Et al. David Kilgore, COPRORATE Headquarters. 2150 River Plaza, Dr. Suite 420, Sacramento, California, 95833. 54. Celine Finance LP. Et al. Joe Davila, COPRORATE Headquarters. 3501 OLYMP US Boulevard, Suite 500, Dallas. Coppell, Texas, 75019. 55. MERS. E.T. Al. Carrie Vanden Bosch, COPRORATE Headquarters. 1134 Municipal Way, Lansing, Michigan, 48917. 56. NationStar Mortgage LLC. E.T. Al. Oba Mr. Cooper J. Bray, COPRORATE Headquarters. 8950 Cypress Waters Boulevard, Coppell. 57. Navy Federal Credit Union, Mary MCDUL = L = IE. COPRORATE Headquarters. 820 Fallen Lane SE, Vienna, Virginia, Texas, 75019. 22180-4907. 58. New York Community Bancorp, INC. C. 0 Flagstar Bank N.A. E.T. Al Thomas R. Kangemi, President and CEO. COPRORATE Headquarters. 102 Dull = FY Avenue, Hicksville, New York, 11801. 59. Air Academy FCU, Glen L. Street, COPRORATE Headquarters. 9810 North Union Boulevard, Colorado Springs, Colorado, 80,924 feet. 60. PennyMac Loan Services, LLC. Sec. PennyMac Financial Services, Inc. David A. Spector, COPRORATE Headquarters. 3043 Townsgate Road, STE. Zoo, Westlake Village, California, 913613027. 61. Chase Bank, Jamie Dimon, COPRORATE Headquarters. 270 Park Avenue, Floor 12, New York, New York, 100172036. 62. Sally Mae John Witter, COPRORATE Headquarters. 300 Continental Drive, Newark. 63. CM sold to Mr. Cooper J. Bray, COPRORATE Headquarters. 8950 Cypress Waters Boulevard, Coppell, Delaware, 19713. Texas, 750194620. 64. Arrowhead Credit Union Darren Wojnarowicz. COPRORATE Headquarters. 8686 Haven Avenue, Rancho Cucamonga, California, 91630. 65. Rocket Companies Inc. Oba Rocket Mortgage. E.T. Al. J. Farner. COPRORATE Headquarters. 1050 Woodward Avenue, Detroit, Michigan, 482261906. 66. BRIDGECREST Auto Funding LLC. Et al. Mary Lee Phillips. COPRORATE Headquarters. 7300 East Hampton Avenue, number 101 Mesa, Arizona, 8520933324. 671 Mortgage Access Corp. D.B. A Weichert Financial Services NMLS. 2731 Eric P. de Klerk. COPRORATE Headquarters. 1625 State Route 10 East Morris Plains, New Jersey, 079502933. 68 SERVEBANK, Servbank Haldka. INC. Kenneth Bertrand. COPRORATE Headquarters. 3201 Orchard Road, Oswego, ILUNOIS 60543 5011. 69. Nelnet Jeffrey R. Nordhoek. COPRORATE Headquarters. 121S. 13th Street, 201 Lincoln, Nebraska, 68508. 70. Village Capital and Investment. LLC Allie Burns. COPRORATE Headquarters. 2550 Paseo Verde Parkway, Suite 100 Henderson, Nevada, 890747129. 71. Westlake Portfolio Management Ian Anderson. COPRORATE Headquarters. 4751 WILSHIRE Boulevard, Suite 100 Los Angeles, California 900103847. 72. New Res LLC. Oba Shellpoint Mortgage Servicing. E.T. Al. Bruce Williams COPRORATE Headquarters. 55 Beatty Place, Steve 500 Mega Siemens 501 Greenville, South Carolina 2960-15116. 73. Santander Consumer USA. Et al. Bruce Jackson. COPRORATE Headquarters. 1601 Elm Street ST 800 Dallas, Texas 75201. 74. Miami-Dade County Clerk of the Courts. E.T. Al. Juan Fernancez Barquin COPRORATE Headquarters. Central Depository Child Support. 73 West Flagler Street, Miami, Florida 33130. 75. Hillsborough County Clerk of Court, et al. COPRORATE Headquarters. 401N. Jefferson Street, Cindy Stewart, Tampa, Florida 33602. 76. Capital One Richard Fairbank, COPRORATE Headquarters. 1680 Capital One Drive, McLean, Virginia 2210-23491. 77. The United States Department of Agriculture, et al. Secretary Tom Vilsack COPRORATE Headquarters. 1400 Independence Avenue, SW Washington, District of Columbia 20250-0003. 78. TD Bank N.A. et al. CEO Leo Shalom. At Corporate Head Office, COPRORATE Headquarters. 1701 Marlton Pike ESTE 200 Cherry Hill, New Jersey, 080032335. 79. The United States Department of Treasury, Office of the Treasurer, et al. Secretary Janet Yellen, COPRORATE Headquarters, 1500 Pennsylvania Avenue, NW, Washington, District of Columbia, 2022000002. 80. Finance Office of Rural Development, et al. Director OR Insured Loan Office, COPRORATE Headquarters, 1520 Market Street, 3005 Street, Lewis, Missouri, 631032630. 81. Florida Department of Financial Services, et al. Financial Officer, Jim Patronis, COPRORATE Headquarters, 200 East Gaines Street, Tallahassee, Florida, 3239965002. 82. Flagstar Bank, Alessandro P. Dinello, COPRORATE Headquarters, 5151 Corporate DRNE, Ref. Request for Information, RFI, 28-116. Troy, Michigan, 480982639. 106. Department of Revenue, et al. CO Child Support Program, COPRORATE Headquarters, 5050 West Tennessee Street, Tallahassee, Florida, 3239900195. 107. Capital One Bank USA NA, et al. Richard Fairbank, COPRORATE Headquarters, 1680 Capital One Drive, McLean, Virginia, 2210-23491. 108. Ally Financial, et al. Jeffrey J. Brown, COPRORATE Headquarters, Ally Detroit Center, 500 Woodward Avenue, Detroit, Michigan, 48226. 109. Select Portfolio Surveillance, NC, Randir Gandhi, COPRORATE Headquarters, 3217 S. Decker Lake Drive, Salt Lake City, Utah, 8411932884. OAP Creditor List. Defendants: Mr. Cooper, P.O. Box 619098, Dallas, Texas, 752619741. Greenstone Farm Credit Services, FLCA 3515 West Road, East Lansing, ML 48823. IRS. AXE Support, Stop 6052. P.O. Box 3894, Ogden, Utah, 844091894. NYS Child Support Processing Center, P.O. Box 15363, Albany, New York, 122125363. Navy Federal Credit Union, P.O. Box 3302, Merrifield, Virginia, 221193302. PHH Mortgage Services, P.O. Box 24736, West Palm Beach, Florida, 33416. Ally Financial Incorporated, 500 Woodward Avenue, Detroit, ML 48226. J.P. Morgan Chase, 270 Park Avenue, New York, 10017. Freedom Mortgage Company, 907 Pleasant Valley Avenue, St. 3 Mount Laurel, New Jersey, 08054. First Mark Services, 121S, 13th Street, number 201, Lincoln, Nebraska, 68508. EMVLP2, LLC, 1 State Farm Plaza, Bloomington, Illinois, 61710. Blue FCU, 2401E, Pershing Boulevard, Cheyenne, Wyoming, 82001. Bank of America, P.O. Box 841001, Dallas, Texas, 752851001. USAA credit card payments 10750 McDermott Freeway, San Antonio, Texas 782880570. First Horizon Corp. 165 Madison Avenue, Memphis, Tennessee 38103. Navient, P.O. Box 9500, Wilkes-Barre, Pennsylvania 187739500. Midland Mortgage, P.O. Box 26648, Oklahoma City, Oklahoma 731260648. M&T Bank, 345 Main Street, Buffalo, New York 14203. Sensible Auto, 26 Mill Plain Road St2D Danbury, Connecticut 06811. Santander Consumer USA, P.O. Box 961245, Fort Worth, Texas 761611245. Arizona Department of Economic Security 6010 North 57th Drive, Glendale, Arizona 853017700. Cuyahoga County CSEA 1640 Superior Avenue, East Cleveland, Ohio 44114. Navy Federal Credit Union, P.O. Box 3500, Merrifield, Virginia 22119. CitiCards CBNA, Citigroup Inc., 388 Greenwich Street, New York, New York 10013. Carrington Mortgage Services, LLC 1600 South Douglas Road, Suites 110 and 200A Anaheim, California 92806. Elan Financial Services, 4325 17th Avenue, SW, Fargo, North Dakota 58103. Wells Fargo Bank, NA 420 Montgomery Street, San Francisco, California 94104. Wells Fargo Home Mortgage, P.O. Box 10335, Des Moines, Iowa 503060335. AT&T Mobility, P.O. Box 6416, Carroll Stream, Illinois 601976416. PHH Mortgage Services, P.O. Box 24738, West Palm Beach, Florida 33416. ComEd, P.O. Box 6112, Carroll Stream, Illinois 601976112. Kathy Yaruso, 435 Greenbrier Drive, Lake Park, Florida 33403. JPMC Home, 700 Kansas Lane, Monroe, Louisiana 71203. Commonwealth Financial, 245 Main Street, Dixon City, Pennsylvania 18519. Service Mac Movement Mortgage, ATTN. Bankruptcy 9726 Old Bales Road St. 200 Fort Mill, South Carolina 29707. City, P.O. Box 790046. St. Louis, Missouri 631790046. Credit One Bank, P.O. Box 95516, Las Vegas, Nevada 891935516. Capital One, P.O. Box 30285, Salt Lake City, Utah 84130. Mr. Cooper, 8950 Cypress Waters Boulevard, Dallas, Texas 75019. American Credit Acceptance, P.O. Box 204531, Dallas, Texas 753204531. Alliant Credit Union, Sunlight Financial, P.O. Box 679220, Dallas, Texas 752679220. Nelnet Inc., 121 South 13th Street, Lincoln, Nebraska 68508. Truist Bank, 200 West 2nd Street, Winston-Salem, North Carolina, 27101. 1 Main Financial, P.O. Box 740594. Cincinnati, Ohio, 45274. Belk Rewards MasterCard, P.O. Box 669815. Dallas, Texas, 75266. Newrez LLC, 1100 Virginia Drive ST 125. Fort Washington, Pennsylvania, 190343276. Department of Education Mahela, P.O. Box 790233. St. Louis, Missouri, 631790233. Tampa Bay Federal, P.O. Box 7492. Tampa, Florida, 336737492. TD Bank, P.O. Box 8400. Lewiston, Maine, 0424384000. Mr. Cooper, P.O. Box 60516. City of Industry, California, 917160516. Bright Cap Financial LLC, 5161 Lankershim Boulevard, St. 250 North Hollywood, California, 91601. Forward Financing, 53 State Street 20th floor Boston, Massachusetts, 02109. Nelnet, P.O. Box 82561. Lincoln, Nebraska, 685012561. Advantage, 1891 Metro Center Drive Reston, Virginia, 20190. PHH Mortgage, 3000 Leadenhall Road Mount Laurel, New Jersey, 08054. Commerce Bank Credit Card 1000 Walnut Street, Kansas City, Missouri, 64106.